Today I want to talk about the difference between two different types of first-party special needs trusts. And first, I should say, what is a first-party special needs trust? That's a special needs trust that is comprised of assets that originally belonged to the Medicaid beneficiary, or the beneficiary who's looking to apply for needs or remain eligible for needs-based public benefits. So an example of this is a lot of times people are receiving a personal injury settlement and they're on Medicaid. They want to keep their Medicaid, or they're receiving a inheritance, or they already start off with, they don't have Medicaid or SSI. They start off with too many assets and they want to qualify for example, Florida Medicaid long-term care program that'll help pay for home care, ALF care, or nursing home care without first having to naturally impoverish themselves. But it's their own asset. That is opposed to a third-party special needs trust, which is comprised of assets that originally belong to somebody other than the person who needs or wants to keep their needs-based public benefits, such as Medicaid or SSI, Social Security income. So we're going to be talking about two different types of first-party special needs trust. The first is referred to as a self-settled special needs trust, and sometimes it's also referred to as a d4a trust, so self-settled and d4a, or a pooled special needs trust, which is also referred to as a d4c trust. So d4c is the same as a pooled special needs trust. Sometimes I'll use these terms and I want you to know what I'm referring to. So we have a pooled special needs trust and a self-settled special needs trust. And first, let's talk about what is similar between these two first-party special needs trusts. First, they are comprised of assets that only belong to the special needs beneficiary, right? That's someone who's disabled or elderly that is looking to be approved for things, needs-based public benefits such as SSI, Social Security income, or Medicaid. And by the way, I'm talking about only Florida, and other states have some little minor differences in rules. So if you're in another state, you need to talk to an elder law attorney or a Medicaid planning attorney in that state. But I think you'll still find this useful. Okay, so it is comprised of that person's assets. The trust funds in either a pooled trust or self-settled trust can only be used for that one person's benefit, right? They won't pay money. Those funds cannot be used in either special needs trust for anybody else's benefit. And the only person who cannot directly access funds in a special needs trust is the special needs beneficiary themselves, meaning they're going to be relying on a trustee. And what the trustee is going to do is, out of the funds in a self-settled trust or a pooled trust, they are going to pay for things that Medicaid, in one example, doesn't already pay for. So they say they're going to supplement, not supplant, needs-based benefits. That's what that refers to. So if Medicaid's already covering it, the special needs trust is not going to pay for it as well. It's only going to pay for things that Medicaid does not already cover. Okay? Those are maybe about it. Let's talk about some of the differences. In a first-party special needs trust, you or the Medicaid beneficiary themselves are able to choose their own trustee. And the advantages to this is you give the money to someone who you've known for a long time, usually a family member, and that person can then take the trust that an elder law or special needs planning attorney like myself creates, and they can bring it to a bank, they can bring it to a brokerage house, and they can open up the account and invest it and hopefully help the money grow, and that's good. But you're also relying on this independent trustee who may or may not be a professional at this to make sure they don't make any distributions that jeopardize the special needs beneficiary's access to benefits, because making the wrong distribution can result in loss of benefits or reduction in benefits. So that's one side of the coin. The other primary difference is that the self-settled special needs trust is unavailable once someone has reached the age of 65. I mean, if they're 65 or older, they no longer have the ability to create their own self-settled special needs trust, regardless of how lucid they are, and they may be smarter than all the 20-year-olds out there, but unfortunately the law is what the law is, and it's sort of an ageist or ageism at its finest, basically saying that if you're over the age of 65, you're not allowed to create your own self-settled special needs trust. And that brings us to the primary difference in what is a pooled special needs trust. These are nonprofit organizations. There are lots of them around the country and around the state of Florida. And these are specially designated trusts that are professionally managed for a small fee. And if you're over the age of 65, or if you don't have anyone that you trust to be the trustee, if you're under the age of 65, you might consider using these pooled special. And their fees, by the way, are not they're not so, I think a lot of people hear professional trustee, they think of something extraordinarily expensive. Like, for example, one of the least expensive pooled trusts that I work with charges $500 one time and then 1.75% over the course of a year. So if you imagine that, you're paying your investment broker 1 or 1.25 percentage points per year, you're paying a little bit more for a pretty valuable service, meaning managing a special needs trust. Now, one of the main drawbacks is typically these funds are not being invested and really the money's just going down. You're not really seeing the growth potential that you might if you had your own independent, non-professional trustee. You could open up a Ameriprise or whatever account and invest that money to really see it grow. There's one other commonality between these two trusts, between a d4a self-settled or d4c pooled special needs trust that I forgot to mention before, which is they both, and this is very important, they both have a Medicaid payback obligation, meaning in either case, whether you're working with the pooled trustee or whether you're working with your friend or family member as a trustee, they have an obligation once the special needs beneficiary has passed away. They have an obligation to notify Medicaid in the state of Florida, and by the way, any other state that they may have received Medicaid benefits in. And Medicaid then sends a lien. They say, here's what we've paid on this beneficiary's behalf. And out of everything that is left in that trust, they have to pay off that lien. And only if there's anything left over do heirs or charities or whoever the special needs beneficiary would otherwise want to get that money be entitled to $1. So, if there's a $50,000 Medicaid lien and $20,000 left in the trust when the special needs beneficiary passes away, it's all going back to Medicaid. If there's a $50,000 lien and $100,000 left in the trust, and 50 of it's going, and then the remaining 50 can go to whoever's designated in that document. That's just how it works. That's another distinction. Again, we're not talking about third-party special needs trust today, but one of the primary advantages to a third-party special needs trust, if your family has the foresight to plan for that, is those funds, because they originated with someone who's not the Medicaid beneficiary, proceeds once the beneficiary passes away does not have to go back to any agency. It can go directly to other heirs or charities or things like that. So there's a little bit more to it than that, but I'm trying to keep this video at a reasonable length. And if you're interested in talking more about a d4a self-settled special needs trust or a d4c pooled special needs trust in Florida, please feel free to schedule a consultation. Thank you.